Welcome back to the Hot Seat essay. In this video, we react to one of the most dramatic segments of the Senzo Meyiwa trial so far, where the courtroom turned into a battlefield over human rights, prisoner treatment, and the law. Right to the end of today's session, we saw Advocate Mnisi nearly walk out, threatening to stop representing accused 3 because of alleged inhumane treatment. But it didn't stop there. Advocate Ramosepele stepped up with a powerful legal argument, citing Section 31 of the Correctional Services Act, questioning the legality of the area commissioner's directive that removed the ankle pads. Right out of the gate, Advocate Mnisi comes out swinging. He tells the court that accused 3 is in pain due to the removal of the protective ankle pads. He takes it further, saying he cannot effectively consult or take instructions from his client because of this pain. Listen to Mnisi's words carefully. If this court insists on proceeding while my client is subjected to this inhumane treatment, I do not want to be seen as part of this violation of his human rights. That is a bold statement in any courtroom. Mnisi is not just objecting, he's drawing a line in the sand. He's saying, either my client's rights are respected or I'm out. This is a rare move for a defense lawyer in such a high-profile trial. It raises a crucial question. Are the accused being treated as if they're already guilty, rather than as suspects who still have constitutional rights? Mnisi's tone and body language tell you everything. This is not theatrics. He's visibly angry. And frankly, if his client is being dragged or lifted into court without the protective pads after using them for 3 years, it does look like an unnecessary escalation by correctional services. Now, here's where things take a legal turn. Advocate Ramosepele steps in, and this is where the debate gets serious. While Mnisi is talking about pain and human dignity, Ramosepele comes armed with the law, specifically Section 31 of the Correctional Services Act of 1998. He reads it out, making it clear that mechanical restraints, like leg irons, are only allowed in limited situations, for safety, to prevent damage to property, or if there's a real risk of escape. And here's the kicker. The law states that mechanical restraints cannot be used as punishment or disciplinary measures. Ramosepele then points out something important. We see discrimination happening where some accused have their protective pads while others, like accused 3, do not. This decision, which apparently stems from an escape at Port Prison, is irrational and unconstitutional. He's essentially saying, why are my clients being punished for someone else's escape at another prison? This argument hits hard because it exposes how arbitrary the directive is. It wasn't tailored for these accused. It's a blanket punishment stemming from fear rather than evidence. Mnisi then delivers his ultimate ultimatum. He tells Judge Ratha, if this court proceeds while my client is in this condition, I will withdraw from representing him. This is not an empty threat. In a trial this complex, changing legal representation mid-trial would create massive delays, possibly months of postponements. It's a smart pressure tactic because the court knows the public is already frustrated with the slow pace of this case. Mnisi's argument is simple but powerful. His client is in pain. That pain affects his ability to follow the trial and give instructions. Therefore, continuing would violate his right to a fair trial under Section 35 of the Constitution. This is a human rights issue disguised as a procedural complaint. And it worked. You can see Judge Ratha becoming more cautious as Mnisi speaks. Judge Ratha doesn't give an immediate ruling. Instead, he suggests a formal complaint be made to Judge Edwin Cameron, the inspecting judge for correctional services. This is an interesting move. On one hand, it shows Ratha is taking the matter seriously. On the other, it looks like he's avoiding making a direct call on whether the accused's rights are being violated right now. He tells the defense, I think I'll make an order now that your clients should lodge a complaint and address it to Judge Cameron. Now let's be real. This doesn't solve the immediate issue. It pushes the fight into a bureaucratic process. But Mnisi and Ramosepele know this game. They want the record to reflect that this directive is being challenged at every level. Then we hear that Correctional Services has agreed to restore the ankle pads. But here's the problem. It's done for the sake of progress in the trial, not because they admit it was wrong. Mnisi immediately calls this out. This is not about convenience for the court. This is about human dignity, about constitutional rights. And he's right. If these pads are being restored just to keep the trial moving, what stops the authorities from removing them again tomorrow? This is a temporary win for the defense, but Mnisi wants a permanent, principled solution. So, what can we take away from this courtroom drama? Mnisi, Mishololo, and Ramosepele are showing real backbone. They're not afraid to challenge the state, even if it slows the trial. The law is on their side. Section 31 makes it clear that mechanical restraints should be minimal and never punitive. Judge Ratha is walking a tightrope. He doesn't want to be accused of violating human rights, but he also doesn't want endless delays. Now, here's a question for you. Was Mnisi right to threaten to withdraw? And do you think Ramosepele's Section 31 argument will have any long-term impact on how prisoners are treated in South Africa? Drop your thoughts in the comments. And if you're following this trial like we are, hit that subscribe button because we're covering every twist and turn.
Accused number 5 does also not, who is also incarcerated at Mampuru, does not have pads on the on his leg irons, and they say this decision was informed by an earlier escape by an inmate from Bavianspoort prison, and a decision was then taken that prisoners will no longer be allowed to put the pads around their ankles, because apparently what happened in that instance is that the prisoner removed the pad, then subsequently removed the leg irons. And we are told that they had to physically carry the accused to take him to, this is now accused number 3, physically lift him up to the vehicle, and yeah, that's how he happens to be here, my lord.
Okay, fine. Where's Mr. Machado then? Yeah, are you? Yeah, you don't have to take the oath. What is the latest instruction about prisoners, so-called, not being allowed to have a sponge underneath their cuffs?
My lord, the instruction was from the area commissioner,
All right.
Mr. Khosa,
Okay.
which we received on the 12th of July, 2025. And the instruction was based on the escape that took place at Bavianspoort,
Okay.
where the offender had the sponge and the cuffs on top. The offender took out the sponge, and the cuffs could easily get out of the leg, and the offender hit the official with those cuffs, and he escaped. Up until today, he was never found. So we only got instruction from our area commissioner as Mampuru that we should not allow offenders to put in those sponges when they come to court.
So did you explain to your inmates at Mampuru?
Yes, I did explain to offender Ngube at the center. I think it was last week, if not last week, to say this is the instructions, and just take note that when you go to court on the 21st, we won't allow you to put the sponges when you go to court. Yes, and the response from him was that if he's not going to be allowed to put the sponge on his leg, he won't go to court. That is what he told me.
And the other inmates, did they also adopt the same attitude?
I'm only having Ngube from my center.
I see, okay.
Yes, I only addressed him. The other offenders, I don't know.
Okay.
Yes, Lord.
So when is this diktat, when is it going to end? If at all?
I don't
don't
know.
know.
I don't know. I don't know.
So it's official. It's not like you're punishing anybody.
No, we are not.
Okay, thanks for the explanation. Thanks.
Thank you.
Yes, Mr. Malui, let's go on.
As the court, please, my lord.
My lord, are we not allowed to respond?
I don't know why you don't respond, because I was asking the gentleman whether it's official. He says it's official.
It does not end up there, my lord.
Hello?
It could be official. I'm saying it does not end up there. It could be official, but we've got the right
Okay,
on behalf of
let's
the
see. What do you want to
accused
say?
respond.
Yes? Yes, let's see.
My lord, I've got instructions.
Yeah.
The accused number 3 is in pains.
Is what?
He is in pains. Yes. He is unable to concentrate. I'm unable to receive any instructions from him. If the court were to insist that despite this gross violation of a human right that he's been subjected to, that this court says he can continue, I wish to inform the court, my lord, and with due respect, that I do not want to be seen to be part of that violation of a human rights, of the right of Mr. Ngube when attending this trial, because he's not only been full cuffed, he's also been handcuffed. Mr. Matlala does not address the issue of him being in handcuffs when his colleagues or when the other accused persons are not cuffed on their hands. The state does not address that too. But as I'm saying, my lord, on account of the fact that Mr. Mncube is saying he's feeling pains that affect his ability to concentrate in the trial, and I'm also unable to get instructions from him because of this inhumanity that he's been subjected to, I am not willing to validate what he is going through by simply standing up here and pretend as if nothing is happening. Mr. Mncube is all right with him. If this court were to say that this trial should proceed despite the complaints that he's raising, then I am going to request that I be excused from representing Mr. Mncube when he is in the condition in which he is. I'll only proceed to represent Mr. Sibiya up until such time that Mr. Mncube gets somebody who will represent him on the condition that he is facing now. In other words,
which condition is that? He's in pains.
He is in pain, my lord.
Yeah, what is wrong with him?
What is wrong with him, my lord?
Yes, what's wrong with him?
He says the leg chains without those sponge things are
No,
injuring
let's
him.
address the question of pains. You say he's in pains. What pains him?
But I'm addressing that, my lord.
Oh, I see.
Yes.
So
He is saying those things, those leg irons, are injuring his leg, his ankle. That's the pain that he's going through.
I see.
Yes. And I am
Now,
saying,
let me just understand. Since 19, is it when this trial starts before Mauma?
It was February of 2022, man.
February 2022.
Yes.
Was he always having the cuffs, Mr. Baloyi, since February 2022?
Well, I assume so, my lord, in light of the fact that the decision to not have pets underneath the foot cuffs was informed by this escape at Baviansport. So I suppose, as Mr. Matala mentioned, this applied from the 12th of July 2025.
Yeah.
this is what Mr. Mncube is saying, my lord, that ever since he started to attend this trial, he has been always having those sponges that serve as a cushion from the leg irons. So it comes as a surprise for him now that he should be told that it's no longer supposed to be wearing these things simply because somebody had escaped at Baviansport. What does the escape of Baviansport have to do with him? Even if that's a national legislation or it's an official statement, my lord, but it is unconstitutional. The constitutionality of which must then be tested. And if the court again were to insist that it should proceed in the manner in which or in the condition in which he is here, I am not prepared to validate that, my lord. Otherwise, I'm going to request that you adjourn, we bring an agent application for that unconstitutionality of that directive to be tested. Thank you.
Yeah, when do you intend bringing it so that I can postpone? When do you intend bringing it?
I don't know. It might take me 3 months. I don't know.
Fine.
Yes.
Doesn't matter.
Yes.
Give me a date so that you postpone.
I don't know. I don't have a date, my lord. It will depend on the court's
I thought you said
attitude.
you wanted to test the constitutionality.
I am
otherwise.
saying if the court were to give a directive that this trial should proceed despite the consents or despite his consents of this unconstitutionality, then I'm going to request that this trial be postponed. It will depend on what the court will rule after this argument.
Mr. Baloyi?
My lord, let me address the court perhaps on what Mr. Matlala misses to tell this court, my lord. And I'm only going to deal with the use of mechanical restraints in terms of the Correctional Services Act 111 of 1998. And that is governed by Section 31 of the Act and Regulation 19 promulgated in terms of the Act. And it reads as follows, Section 31, my lord, subsection 1. If it's necessary for the safety of an inmate or any other person or the prevention of the damage to any property, or if a reasonable suspicion exists that an inmate may escape, or if it is requested by a court, a correctional official may restrain an inmate by mechanical restraints as prescribed by the regulation. And then Section 31, sub 3A. When an inmate is in segregation and mechanical restraints are to be used, such use of mechanical restraints must be authorized by the head of the correctional center, and the period may not, subject to the provisions of paragraph B and C, exceed 7 days. That is what the court asked. Mechanical restraints may only be used for a minimum period necessary, and this period may not, subject to the provisions of paragraph C, exceed 7 days. Paragraph 3C, 31.3c, my lord. The National Commissioner may extend such a period for a maximum period not exceeding 30 days after consideration of a report by a correctional medical practitioner or psychologist. Paragraph 31.3 D. All cases of the use of mechanical restraints may be reported immediately by the head of National Center to the National Commissioner and to the inspecting judge. And then 33.5, an inmate who is subject to restraints may appeal against the decision to the inspecting judge who must decide on within 72 hours after receipt of the complaint. Paragraph 31.6, mechanical restraints may never be used as a form of punishment or disciplinary measure. And paragraph 31.7, mechanical restraints, in addition to handcuffs or leg irons, may only be used on inmates when outside their cells. Now, my lord, we see a discrimination happening where some accused from the same center have got those protections and Mr. Mnube does not have. And the reasons that are given, my lord, I'll submit, is very flimsy. You are saying somebody escapes in Bavianspoort, therefore let's punish Mr. Mnube for that. Because for me, that's a sort of punishment. No rational reason is given except to say there was an escape in Bavianspoort, my lord. I'll leave it at that, my lord. But I wanted to point that the period is not indefinite, my lord, for the removal of the protections, even the leg irons themselves. And there are certain areas where leg irons are not even allowed, my lord. That's the court, please.
Yes, sir.
My lord, in respect of accused number 5, Mr. Ntuli, he's also kept in Kgosi Mampuru, my lord.
Kept what?
In Kgosi Mampuru.
Yeah, okay.
Yes, my lord. He also has the same complaint, my lord, that he has been attending this case since 2022, when we started this matter, my lord. And at all times when he was attending court, these pets have always been put on him in order to prevent the injuries that are caused by the leg irons, my lord, to the ankles. And it is only today, this morning, when he was told that he is not allowed to use pets anymore, which he has been using since the inception of this matter. He has never been informed of any reasons behind the decision that has been taken by the area commissioner. The reason, which has been explained to this court by Mr. Matlala, my lord, has never been communicated to Mr. Ntuli. Above that, my lord, I submit that even if it's the reason that Mr. Ntuli should be punished or penalized for someone who escaped from another prison, my lord, that communication I have requested as the legal representative of accused number 5. I've requested that communication for the area commissioner from Mr. Matlala to say, give us the communication, whether it's an internal memorandum, whether it's an email, the instruction that has been given, so that we can be able to apply our mind and take the instruction, because someone's right is affected by such decision by the area commissioner, which is the constitutional right of the accused before this court, my lord. My lord, accused number 5 says he is also affected by this decision to such an extent that he can't concentrate, my lord, on the proceedings because of the pain that is caused by the leg irons when he's moving. The distance that he's moving from the cell to the car and from the car inside this court premises going upstairs to this court, my lord, which also makes more impact on him. My lord, the decision, the accused number 5 is affected by such a decision, and therefore we ask, my lord, that a directive be given to the correctional to continue in supplying the protective pads that have always been provided for the past 3 years, my lord, in order to protect such inhumane or such injuries that are occurring to the legs. My lord, also, if there is someone, if we're to apply our mind to the decision that has been submitted before this court, it means if there is someone who is escaping from another prison, then other prisoners from other center will have to be punished or will have to be penalized. That decision, my lord, or such occurrence is irrational, it's unlawful, because it has no basis. There is no profound or proper reasons placed by the area commissioner as to why these accused should be affected by such an escape, my lord. And we have not been informed as to how many, if we have not been informed if there are any other measures that can be put in place in order to ensure that the escape does not happen, other than the decision that has just been taken by the area commissioner. Therefore, we submit, my lord, that the decision by the area commissioner is unlawful, is wrong, and inhumane, and it is unacceptable. Lastly, my lord, the manner in which the accused number 3 has been brought before this court undermines the justice system of this country. he cannot be dragged by the group of warders, dragged up to this court in such a manner, my lord, as we have been told that he has been dragged out from the cell because pads have not been provided for. So the substitute that has been put is to get these big men to come and lift him up and bring him in court. It is inhuman to us. It is affecting us also as well when we see such occurrence happening inside in court, my lord. Therefore, it is my submission, my lord, that the decision that has been taken by the area commissioner, my lord, is unlawful, is irrational, and is wrong. It cannot be affected. It cannot be accepted, especially in this case, my lord, that is affecting the client's concentration in order to concentrate during the trial, my lord. I submit, my lord, that the accused number 5 also is unable to proceed with the trial because he's affected by such occurrence. Those are my submissions, my lord. Thank you.
Yes, Mr. Nomalo?
No, I have nothing further to add.
No, consult your client.
My lord,
Go and consult your client also.
I must approach him.
Yeah, I want to hear
Oh, all right.
what he says.